Hi everyone, I am with Mr. Nicholas Peacock, who leads the arbitration practice.
Yes, well, I'm an arbitrator and advocate these days.
Amazing, that's even better. And Mr. Peacock is going to speak on a panel which has a very, very interesting topic, and a topic that I'm very interested in, which is the role of in-house counsels in arbitration and mediation and all of that. So I want to ask you, what do you see as the role of in-house counsel in the world of arbitration or mediation?
Sure. Well, look, they're the key stakeholders. They're the owners of the process. Often on behalf of the business, they represent and they act for. We as counsel, we're stakeholders. We guardians of the process, but we're here to act on behalf of in-house counsel. So they are all important. And I think it's important that arbitrators, tribunals, and counsel, when we're acting, remember that the most important party in this whole process are the litigants, the claimant, and the respondent in the arbitration.
And what do you see as some of the good qualities, the good characteristics of a good in-house, somebody who's controlling the process in a very efficient way? Because I think, having been in-house myself, I think that sometimes we don't realize that we are supposed to control the process. We are supposed to instruct our instructing advocates, and then, maybe even the tribunal to the extent that we can, on what is it that we want. And I think sometimes we lose sight of it. So what would you say to that in terms of something good and some of the challenges that you face with in-house?
Yeah. Well, look, our job is to work with all in-house counsel, some of whom are very experienced in arbitration, some of whom, of course, will be doing it for the first time. I think what we need from our clients is to take decisions when the point comes. We can advise, we can tell people what we would do if we were in their position, but ultimately we won't have the full perspective of the business. We won't know all the dynamics that are affecting the in-house counsel and their thought process. So ultimately we have to lay out the options and in-house counsel take those decisions.
And what do you think are some of the best practices? Imagine that there are, in-house counsels or young lawyers who are listening, who want to get into this. What is the kind of advice that you will give in terms of what is most helpful to an external advocate from an in-house counsel?
Well, I think one lesson I learned early from some of the clients when I was a young lawyer is that in-house counsel need an owner of the dispute within the business itself.
Yes.
It may depend on the role of the in-house counsel and how much executive power they have within the company, but very often they will, of course, have their internal clients as well. I think what helps them and helps us in the process is if they can get an owner of the dispute within the business, someone who actually is the coalface, who deals with the balance sheet, and who can help them. Again, I mentioned decision making. That will be the counsel on behalf of the company, but also it'll probably be their internal clients making those decisions. So I think early on, in-house counsel need to try and find an owner, an ally within the company who will help them run the disputes and take ownership.
Fabulous advice. That is really, really good advice, because I can relate to what you're saying with my background. But this advice, which is that as in-house, find someone within the company who can be your ally and who can help you execute the decisions, or who can help you take decisions internally so that you can sort of pass it on to your external advisors. And my last question to you is, how do you see cultural differences playing out? Because you are in the realm of international arbitration, and sometimes the management and the in-house may be from different geographies, and then the in-house and the external, and then they are instructing advocates, or the tribunal may be from different geographies. So how do you see cultural differences sort of playing out in this setup? And what would be your advice to say both the external advocates and in-house as to navigating these cultural differences? What are some of the tips?
Well, it's one of the beauties of international arbitration that you have these cultural mixes. You may have a tribunal from 3 different traditions. You may have a client from one jurisdiction. You may have counsel from other jurisdictions. It's part of the pleasure and the fun. I think the important point is to recognize the perspectives and the backgrounds, to try and work out how you deal with them, how you address them, what will work and be persuasive, what might offend, what will be difficult for some parties or some tribunals to do or say, whether it's decision making or whether it's the way they're going to argue a case. There's no simple solution, because you have to address it and you have to deal with it. If you have a tribunal from a certain jurisdiction, you as counsel will have to try and get on their level, from their perspective, to argue in a way that will persuade them. And likewise, if you are the tribunal, as I sometimes am, you have to try and recognise that different counsel will have their own perspectives. They won't understand perhaps how you're seeing the case. You need to put yourself in their shoes let them make their submissions, and then if you need different answers, you ask different questions.
Okay. I wanted to ask you, because you said this, I know I told you it was the one last question, but I'm compelled to ask you, do you see these kind of cultural differences or some of these sort of nagging problems that come and, kind of irritates the arbitral process? Do you see an institutional arbitration process sort of bringing this down, and it may be a better solution versus an ad hoc process?
I think it can help because it gives more of a playing field. So if you have an arbitration run by an institution such as MCIA, then that will have a common set of rules, a common set of expectations around how arbitrators will behave. It may also put a framework around how counsel should conduct themselves, certainly procedurally and sometimes even behaviourally. So I think institutional arbitration puts some guardrails, if you want, some parameters around the process. I think it can be helpful, which is not to say you can't make ad hoc arbitration work well, but you may find if it's a cross-cultural situation that a single institution can help just to level things out.
Thank you. On that note, thank you for being
My
part
pleasure.
of the Daily Lawyer podcast.